Certainly, I recognize that there are inconsistencies in the state's evidence, both circumstantial and direct. I believe that because I must judge this motion on the evidence taken in a light most favorable to the state, at this stage of these proceedings, inconsistencies are resolved in favor of the state. A reasonable, and the reason this is because a reasonable mind can draw conclusions about those inconsistencies which may differ substantially from those conclusions propounded by the defendant. Reasonable minds can differ. Using this standard, I find that the circumstantial evidence supports the finding that this 9-month-old infant was in fact the victim of an abusive head trauma, which indeed caused his death, and that this trauma was inflicted by the defendant. I'm not going to go through each and every aspect of the evidence presented. For purposes of this motion, that statement is enough. The fact that the testimony has been elicited that he was the victim of shaken baby syndrome or blunt force trauma, which may be seen in and of itself as an inconsistency, is again irrelevant in light of my previous observations. Now, that finding in and of itself does not dispose of this motion. As I mentioned, the evidence taken in the light most favorable to the state must support a finding that the state has proven beyond a reasonable doubt all of the elements of the offense of first-degree murder. And to that end, the defendant maintains that the state has failed to prove the requisite mental state. Mental state can also be proven by circumstantial evidence. The state must prove beyond a reasonable doubt that while performing the act which caused the death of the deceased, the defendant knew it would cause his death or knew that the act created a strong probability of death or great bodily harm. In support of her motion, the defendant points out that the evidence elicited indicates a quiet, comforting demeanor and a lack of consciousness of guilt on the part of Mrs. Mock. But even here, there are some inconsistencies about exactly what Ms. Mock was observed doing. Furthermore, there's a period of time in which she was observed doing, that no one observed her doing anything, because there was nobody in the home other than another infant. I believe that by finding that, again, at this point of the proceeding, the evidence supports the manner that death was inflicted, also supports a finding of criminal intent. The violent shaking of a 9-month-old infant by an adult supports a finding that the perpetrator was consciously aware that her conduct was practically certain to cause a particular result. Again, that's taken the evidence, all of the evidence, in the light most favorable to the state, which is the standard that I must use at this point of these proceedings. Lastly, I find that the issue regarding venue has no bearing. Chapter 720 ILCS 5/1-6 provides that the proper place of trial is the county in which the criminal act is alleged to have occurred. That section further provides, however, that the state is not required to prove that the alleged offense took place in any particular county. Finally, the law provides that any issue regarding the place of trial must be raised by the defendant in a pretrial motion. Otherwise, that issue is waived. So, for the foregoing reasons, the defendant's motion for acquittal after the presentation of the state's case is denied.